basically the court overturning the lower court, saying just the opposite of what the court had said 4 years ago when it found the Talwars guilty of murdering their teenage daughter, saying that, look, there's no clinching evidence against the Talwars, there's only the benefit of doubt, that you have to give the benefit of doubt to the Talwars, there's only circumstantial evidence and perhaps most crucially insinuations of the media. So would you say, from what you've heard so far, it seems to be what many have called it a media trial? The media had a clinching role to play 4 years ago when that verdict came in, because we're looking at the same evidence, we're looking at the same arguments, but we're looking at a completely different verdict.
Well, definitely. First of all, Sarah, the media trial aspect has been covered by Supreme Court. In fact, Supreme Court agreed, which is why for some time there was a bar on the kind of stories that you could do in this particular case because of the kind of insinuations that were made. But let's look at what the grounds that we know till now. Till now, what Alok Pandey has been reporting from the Allahabad High Court is that the judges, while clearing Rajesh and Nupur Talwar of murder, is because they've said, give them the benefit of the doubt. Let me explain to our viewers what they mean by that. Basically, when you convict someone, it has to be beyond doubt. There are far too many questions right from the word go. Let me just remind our viewers how the CBI concluded the case. The CBI actually went to court when they concluded the case and said, we want to close the case. This was in 2010. They said, because we can't conclusively say, we know perhaps what happened, but we can't conclusively say it for sure. We are going by circumstantial evidence to say that there was no forced entry. There were only people inside there were 4 people inside the house, 2 of them are dead. So we can presume, they were going by presumption, that the Talwars were guilty of the murder. But they did not have anything conclusive. And that seems to be the position that the High Court has taken as well. The High Court talking about benefit of doubt, the High Court talking about inconclusive evidence. So in a way, this goes back to what the CBI had said. What is very, very significant perhaps is to look at the lower court's judgment, Sarah. The trial court actually said what CBI stopped halfway by saying we can assume. The trial court framed charges on behalf of that. So in a way, this will bring to question the way the trial has been conducted, because while the CBI said very conclusively in its closure report, we think the parents did it, but we don't have enough evidence. And let's not forget, the CBI, after doing investigations, after having 2 separate teams, there are so many aspects of this case and ups and downs. Let's not forget that one particular CBI team right in the beginning said that it was the servants, the people who were working in their house, the 3 helps who did it. Then a second CBI team is brought in, which went the opposite way, which actually agreed with the Noida police in saying, no, it was the parents which did it, and they agreed with the whole assumption and of the Noida police saying that it was a crime of passion. The motive was because the Talwars were very, very angry because they caught Hemraj and Aarushi in a compromising position. The court's order today is very clear. Don't make assumptions. You don't have evidence. You can't go by that. What is very significant is that the Talwars have now been in jail for, as Alok was saying, for 4 years now. They've been in Dasna. The High Court's detailed judgment should perhaps be an indictment of the agency, how they closed it, and then how the trial court went ahead, and where the CBI stopped, they actually went ahead and said, no, that presumption, we can frame them for murder.
You say it's an indictment of the agency, Sunetra, but also interestingly, as you pointed out, the CBI actually wanted to close this case, and then it was Rajesh Talwar who actually filed a protest petition. Is that correct? And you actually asked him that question, whether they regretted it at one point when you had interviewed them.
Well, the protest petition was a different kind of thing. The protest petition was, look, how are the people covering it? What are the statements that are being made at various points of time? They were very, very hurt also by the kind of stories that were coming out. And why is it that their appeal wasn't being heard by the Allahabad High Court? Why didn't things happen much earlier? Many people at that point of time thought that by actually questioning the judiciary, Rajesh Talwar had made a huge mistake about it. But Sarah, This time today, we have to look at what the investigation has found. The question is, what the High Court order also implies is that we don't know. The court says there's no evidence that the parents did it. That means the question so many years later, 10 years later is, well then who killed Aarushi Talwar?
Alok Pandey, let's ask you that. That's an absolutely important point here, right? It is the worst form of injustice to have a parent wrongly. Okay, let's just try and get Alok Pandey back on the phone line. But let me just take our viewers through what has happened right now. The breaking news that you're listening to right now is a new verdict coming in the Aarushi Talwar case. The High Court overruling the lower court's verdict, and it has declared that the dentist couple, Nupur and Rajesh Talwar, are not guilty of murdering their teenaged daughter, all of 14 years old, Aarushi Talwar, in 2008 at their home in Noida. This is a verdict that is just coming in. It's come in minutes ago at the top of the 3 o'clock, just at 3 o'clock it came in, this verdict. Remember, Aarushi was found dead in her bedroom. Then a day later, about 24 hours later, Hemraj, the family's domestic help, was found killed on the terrace. The Talwars were sentenced to life in prison in 2013. They have been in jail for 4 years. They have always maintained that they are innocent. This has been a media trial. They have been wrongly found guilty of the murder of their own child, of their only child, Aarushi Talwar. They have appealed against their conviction, and today their conviction has been overturned. Let's go across to Alok Pandey, who's been following this case in court. Alok, you know, we were just saying that it is the worst injustice if you would have a parent found wrongly guilty of murdering their child, their only child. But the question now is, then 10 years on, who did murder Aarushi Talwar? What does this case mean? Does this mean that investigation, I mean, the verdict coming in today from the Allahabad High Court, what does this mean for the case? Does it mean that case is reopened and a new investigation is launched to find out who's behind the murder if it's not the Talwars?
Well, I think first of all, the Central Bureau of Investigation that is handling the case will have to decide whether they want to go in to appeal in the Supreme Court or not. That is the first thing, because this case has reached the High Court. You have the option of an appeal in the High Court, in the Supreme Court available. We were speaking with the Talwars earlier, with people associated with the Talwars, and they told us that if they were on the wrong side of the judgment, they would certainly approach the Supreme Court. So I think it will be interesting to see what view the CBI takes now of whether they need to go into the Supreme Court to appeal or not. If that appeal is actually filed, then you will have another situation where a higher court, then the Supreme Court will then look at the same evidence and see whether the High Court made an error of judgment or not, but that is for later. It might take 2 or 3 more years. In the immediacy of it, it means that Nupur Talwar and Rajesh Talwar will both walk out of Dasna jail either today or in the next 1 or 2 days. I also want to briefly talk to you about what I saw in the courtroom, because I think it is important to give our viewers that perspective also. Now, there are about 250 to 300 people inside that courtroom. It was suffocating. The judges sent word at about 2 p.m. in the afternoon that they would not come and sit at 2. They would actually come at 2:45 p.m. They came in at 2:40. They first spoke to each other. They said that wait for a while, we want to discuss something with each other. And then one of the judges started to read out the judgment. Now, like I said, generally you have a situation where the judge just reads the operative part of the judgment and says that the rest of it will be available online. In this case, the learned judge spent 10 minutes reading out. And like I said, it was a packed room, so you couldn't really catch everything that he was saying, but I did manage to catch snippets. Now, one of them, of course, was the benefit of doubt. The judge said that, look, if there is a benefit of doubt situation, if there is a situation where you have doubt that points either to a conviction or to an acquittal, we are inclined to give an acquittal in this case. They also said that, look, there is no irresistible conclusion. That's the word. Those are the words that the learned judge used. He said that there is no irresistible conclusion that the accused are the people who actually murdered Aarushi Talwar and their domestic help, Hemraj. They also said, if I can just go through this, they said that the golden rule in justice is that if you have facts and if you are under doubts, under some kind of doubt.
Alok, will you just hold on? We have Mr. Aditya Vadva, who is the lawyer for the Talwars. He now joins us on the phone line. So first and foremost, congratulations to you. It's a huge day for you and your clients right now. Can you take us through exactly what the court said in its verdict today first?
Look, unfortunately, I haven't had the chance to go through the judgment yet. but it is remarkable, and it further strengthens our belief in the criminal justice system and the fact that we have a robust criminal justice system, that the High Court has finally now acknowledged the truth. Justice, as much as it can be done to the parents, has been done today. They have suffered a lot over the past 8 years. Not only have they lost their daughter, but they have spent more than 4 years in prison on accusation of having killed her and their domestic help. So it is the story is being received with a profound amount of relief by us and by the parents. And I'm greatly indebted and thankful to the High Court for having done this.
So you said this has been received with by both you and the parents of the Talwars have heard the court's verdict. Do you know what their reaction has been?
Of profound relief.
And what happens now? They've been in jail in Dasna for the past 4 years. So what happens now? Are they being released? Have they been, I mean, they've acquitted, as in, are they out on bail? How does this work? What happens right now?
Okay, so they are as of right now in custody. The order will take, I would assume, at least a couple of days to go to the trial court, post which they will be released. And if the CBI decides to challenge it, then that will be another battle that we will be ready to fight. But I hope that the CBI sees sense and leaves the matter where it is, because initially they had filed a closure report believing that there isn't sufficient evidence against the Talwars, which I believe was a prudent thing to do. And that prudence is now also being recognized by the High Court, which has also said that there isn't sufficient evidence against the Talwars. So I think the matter should come to a closure now. We should just let it be and respect the privacy of the parents, acknowledge the misery that our system, our society has caused to the parents, and feel sorry about it and let it be. I think that's what one must do now.
Mr. Wadhwa, as you're a lawyer and you know how this works, could you clarify for us what happens now? Because the question is, of course, as you said, we should acknowledge the misery that these parents have had to go through for the past, over a decade, for the past 15 years. Today, the court ruling that they were wrongly accused, they've wrongly been called murderers of their own child. But the question, sir, of course, is then who murdered Aarushi Talwar and what happens to that case now?
Look, if you remember the facts, the CBI had arrested 3 of the friends of Hemraj, who they had said had visited the house on the night of the murder. So if one was to point suspicion and point blame, it would be towards them. But I do not want to commit the mistake that all of us committed when these Talwars were put on trial by doing the same thing against these people. At the end of the day, one must recognize that as of today, and it is unfortunate that due to serious lapses in the investigation, enough evidence was not collected in the spot. And today, unfortunately, you cannot repeat the mistake that we had made with the Talwars with somebody else. We do not have evidence, there isn't any evidence, and just let it be. The question as to who actually did it, and there is a murderer at large, and that should appall the society, yes, it should, but it's a mistake made by us in the year 2008. It's a mistake made by the Noida police in the year 2008. It's a mistake made by the CBI during investigation from 2008 to 2012. But let us recognize the mistake and also recognize that it can't be rectified. So let us try and make the system more robust. Let us try and improve the system. Let us ask these larger questions and let this case be.
Mr. Wadhwa, hi, this is Sunetra Chaudhary here. I was covering the CBI. I just wanted to ask you, which arguments do you think won the appeal for you? Because the CBI, it's very interesting. We were just reporting earlier how they changed their position. Initially, first they put in their closure report saying that there isn't evidence, but then the court framed the charges. What is it, do you think, during the appeal, your arguments which won you this case?
Look, I need to only point out at one fact, and it's not an argument. It's as a matter of fact, let me point out, which demonstrates the innocence of the parents. If the case of the CBI is that the murder happened in that room where Hemraj and Aarushi were both present, They found DNA of Aarushi, blood spots of Aarushi from more than 15 locations in that room. There was not a single blood spot of DNA or DNA of Hemraj found in that room. Faced with this this fact and unrebuttable fact, the CBI cannot make an allegation, cannot aver in court that Hemraj was murdered in that room. And if he wasn't murdered in that room, that should necessarily result in an acquittal, and which is what has happened. So I really need not say anything more but for that one simple fact, which demolishes the case of the CBI.
All right, Mr. Wadhwa, going back to what occurred in court, the grandparents of Aarushi Talwar were in court with you when this verdict was announced?
No, Mr. Chitnis and Mrs. Chitnis have been really unwell over the past few months, which is why Nupur had gotten bail in order to be with her parents, but they could not travel to Allahabad to be with us during the argument.
And Rajesh Talwar also has been unwell over the last few days. Some reports in the press that he had been suffering from high blood pressure in the run-up to this verdict?
It is unfortunate. They are very Rajesh's health has been deteriorating over the years steadily, but now this news should bring them some amount of relief, and I hope that they get back to get their life back to track when they are released.
So you also mentioned that there is a chance that the CBI could challenge this verdict going forward.
Look, theoretically speaking, yes, but practically speaking, I think a prudent course of action for the CBI and for everyone else to adopt is to recognize the mistakes that we have made in the past, recognize that these mistakes cannot be rectified, and just let it be.
Because the CBI judge who had relied heavily on the circumstantial evidence, the very circumstantial evidence that the judges today have said is not enough to convict these parents, Aarushi Talwar's parents, the same CBI judge had also not just convicted the couple sentences of not just killing their daughter, they'd also said that they had destroyed evidence and that they had filed the wrong FIR with the police.
Look, these were allegations made by the CBI initially, and frankly, they were meaningless. The one allegation of destruction of evidence was that they got their house painted more than 2 years after the incident. That really is not a sensible argument to begin with. If there is no prohibition from me getting my house painted, and if I do so 2 years after the incident, where is the question of destruction of evidence?
All right. Lastly, Mr. Wadhwa, let me ask you this question. We had a lower court that gave a verdict that said they were guilty based on the same evidence today that a higher court has said they're not guilty. So would you say it was a trial by the media in the former case?
Look, I would be very frank and say that a lot of blame can be pointed towards the media, and a lot of what was happening in the trial court was on account of or influenced by the media publication which was happening at that time. But the less I say about the learned judge in the trial court, the better it is. Lest I am hauled up for contempt of court. I have utmost respect for the judiciary at large, but I have my reservations about that learned or perhaps not so learned judge.